You hear me?
Yes.
Okay. I think all of that needs to be explored and a discussion had with you about all of that before you make some decision about what you're going to do.
Yes, because I was never told about it would affect my nursing.
Hold on. I
I'm
don't.
sorry.
A college prank turned courtroom drama. A nursing student from Ohio faces charges after playing with a taser in her dorm. What starts as a light-hearted mistake quickly becomes serious when the judge realizes she may not understand the legal weight of her guilty plea. Watch closely, this one ends very differently than you'd expect.
I worked really hard, Miss Singletary, to make sure I didn't mess up your name this time. I did pretty good. Aren't you proud of me?
Yes.
Thank you. All right. What are we doing? She's entering a plea.
Yes, Your Honor, I believe that we're already
Are
done.
you sure this time a crime's been committed?
We are extremely sure, Your
Okay.
Honor.
I have before me a plea form that indicates that she's pleading to disturbing the peace, the 90-day offense. Upon her successful guilty plea to that charge, the count one, the possession of a taser, this is very much in the same vein as the other one earlier today, will be dismissed. She is also agreeing to forfeit any interest in the taser currently held by the UFM Police Department or EMU Police Department.
That is correct, Your Honor. If they have an agree with Ida?
It was.
Oh, I see it scratched off to the side, but it says Haida.
College.
All right, no, that's fine. All right, I just thought you guys think you're big. I just I don't have defense counsel's signature on the plea form.
Your Honor, if I may approach.
Yes. You did sign it. All right. What here? That's your signature?
Yes.
All right, whatever.
She's pleading guilty, but notice how uncertain she sounds. Every yes feels rushed, almost automatic. A guilty plea isn't just saying sorry, it's giving up your right to a trial, appeal, and more. The judge senses hesitation, and that's where things start to change.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes. Wait,
State your name again for the record.
Udai Singletary.
All right, ma'am, it's this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days and or a $500 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You had previously signed an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you will be waiving all of the rights contained on that form.
Yes.
Understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty?
Yes.
Hang on one moment. What?
Okay.
Find my information here. I'm sorry. On the date of December 12th, 2024, at the location of Putman Hall, EMU, Eastern Michigan University, City of Ypsilanti. What do you do on that date that makes you think that you're guilty?
We were just playing around. That line says it all. She claims it wasn't her taser, just a misunderstanding. But in Michigan, tasers on campus are no joke. Intent doesn't always matter. Possession alone can lead to charges.
Me and my friend were playing around. We're both from Ohio, and we didn't know that the laws are different here, and we were playing around with the taser.
You were playing around with the tasers. You had a taser?
It was not mine. It was the other girl involved with this case.
Your Honor, may I have what here?
That always goes badly, but yeah, go ahead.
Thank you. Ms. Singletary, on the date the judge mentioned, were you and your friend in the hallway at the dormitory with the taser in your possession?
Yes, for about 3 seconds.
Okay, and when
You say 30 seconds or
3. 1, 2, 3.
while you were doing that, were you and your friend engaging in each other in such a way where you were holding the taser and that gave concern to a staff member who contacted police?
Yes.
What exactly were you doing, Miss Singletary?
We were playing, me and my friend are both from Ohio. We were playing around with her taser that she had brought onto the campus. I never would have known that there was a taser if it would. It's her taser. We were playing around. We ran into the hallway for about 3 seconds. And once we noticed that, like, we're doing too much, we came back in and now we're here. So
When you say you were doing too much, do you mean that you were saying you were creating a scene that caused attention?
yes.
Is this case related to the other?
No, Your Honor, may I report here?
Sure.
The Singletary, did you chase your friend slash roommate with that taser?
Yes. It wasn't my
And did you-
roommate though.
Okay, your friend, and did
Yes.
you arc it to activate it while you were chasing her?
Yeah. Can I say something? I'll just say yes, yes.
Well, no, well. Okay.
The judge spots confusion right away. She's unsure if she even activated the taser, a clear red flag. If a defendant doesn't fully understand what they're admitting to, the court can't accept the plea. The judge knows it, and he's about to stop this train before it crashes.
Can I
get
say
it.
something?
No, just listen. I know, and it gets hard. This is the second time that we've been through this. But here's the thing. What I don't want you doing is I don't want you just saying something for the purposes of just saying it. If somebody asks you a question you don't know, it's okay to say I don't know.
Okay, I'm gonna say I
But
don't.
What I need, go ahead.
I'm gonna say I
You're gonna-
don't know to be activating it in the hallway because when we were in the hallway, there was nobody out in the hallway. That's why we were so surprised when the police came. We actually went to we just proceeded with our day. Like we were not even in there when the police came. We never were arrested or anything. That's why this whole case was surprising to me because I never got like arrested. They did end up taking the taser, which because she said it was hers. I never knew it was gonna fall onto me because I never got removed from school. I never got any of that. My friend did, and they said because it wasn't mine, it didn't really have anything to do with it because I don't believe that I activated the taser. I will say that I did have it in my hand in the hallway, but I can't say yes to me activating it in the hallway.
Miss Singletary, while you had the taser in your hand in the hallway, were you chasing the other person?
Yes. But when you say chasing, it was literally a door over, as you can see in the camera view that you have, I believe. It was never down the hallway. There was literally nobody in the hallway.
You guys done?
Yes,
Hey.
I'm done.
No, not you.
Oh,
You're
sorry.
good.
I'm sorry. Can I say something else?
Heck, why not? Everybody else has.
I'm sorry. I just feel like I should, even though I'm saying I don't know to some of these things, I feel like I should just go through with it because my friend did end up going through with hers, but our situations are different because it actually was hers. I feel like if I keep just pushing it back, it's just going to be more and more court dates, you know? This is new. I never had nothing going on like this.
Okay, okay. You know, Miss Singletary, I get it. I hear you. But I hear you, but I am of the belief you don't think that you've done anything wrong as I'm listening to you.
That's what
And
I'm
as I'm
saying, but I
listening,
understand the
hold
tone.
on,
Sorry,
hold
sorry.
on, hold on. But I think you're saying things so you can try to get it over with. And I'm not
Yes.
saying that there's anything wrong with that necessarily. What year are you in school?
I'm in my second year. Next year, I go into actual nursing school.
Council approach. Singletary.
Yes.
All right. Here's what I'm going to do. Right.
Mm-hmm.
I don't think you've done anything wrong. That's not sympathy, it's a judge protecting a young woman from making a mistake. She's pleading guilty just to get it over with, not because she truly believes she's guilty. That's why the judge steps in.
There are two major concerns here, and I have to make sure before I take a plea that everything at least has been explored and explained to you. Part of the reason that we're here today is because I didn't feel that that was happening the last time, right?
Okay. Yes.
So we're here now. I have some concerns about what your legitimate feelings about your participation in the case are
Mm-hmm.
and whether or not you're really guilty of anything. And so I have some hesitancy to accept your plea based upon that. But there's a more overriding issue in a certain respect for the court, and that's as to whether or not you've fully been advised of all of the reasonable consequences that are there, including what are called collateral consequences. One of those collateral consequences for you revolves around your education, right?
Mm-hmm.
And what's your aspirations in terms of being a nurse are, correct?
Mm-hmm.
So there needs to be some.
Then comes the bombshell. Her nursing future could be at risk. Even a small misdemeanor can block medical licensing. The judge pauses everything to make sure she understands the long-term cost, not just the fine, but her entire career.
Understanding, or at least an assessment. I'm trying to put this very carefully, but an assessment of what it may mean for your entry and maintaining yourself in nursing school, as well as once you finish that with flying colors, whether or not there may be ramifications regarding licensure. You hear me?
Yes.
Okay. I think all of that needs to be explored and a discussion had with you about all of that before you make some decision about what you're going to do.
Yes, because I was never told about it would affect my nursing.
Whoa, hold on. I don't want to know what you and your attorney may or may not have discussed. Okay.
Mhm.
Because I don't get into that, and that is whatever it is. But when I have somebody like you, particularly who's a student, you tell me what you want to do. I know just based upon my experience, and I guess the being here since the dinosaurs, what can possibly happen. Okay. And I want that at least talked through with you. It may be nothing. It might be something, but it's a risk, certainly, that you have to assess. And I'm not, and for me, I'm just telling you, Miss Singletary, the way I look at it, probably wouldn't do any jail time. Probably going to be a fine, then you're done with it. But for me, this is about a bigger picture, and that's what you want to do with your life in your future. So, in that regard, that's a long way of me saying, once again, Miss Singletary, I am not taking your plea today. Okay?
Okay.
Not going to do it. And quite frankly, nobody can force me to do it, so I'm not doing it. I'm going to adjourn this out to allow that entire conversation to take place so you understand what are not only maybe actual consequences of your plea, but what may be that collateral stuff coming at you coming up into this next year and even beyond that.
Okay.
Fair enough?
Yes.
I know you said you wanted it over. You mad at me?
No.
Okay, I don't care, but I just thought I'd ask. Okay. Here's what I'm going to do. Probable cause conference in this case is going to be adjourned to November 6th, 2025, 9 a.m. or as your invite indicated. This time the defendant's bond broken guilty.
Thank you. Have a good day.
And finally, the judge refuses her plea. He protects her from rushing into something life-changing. Instead of punishment, he gives her a chance to think. Rare compassion from the bench. If you found this case eye-opening, hit like, comment, and subscribe for more real courtroom breakdowns.